There are a lot of terms that get thrown around with custody: sole custody, physical custody, legal custody, joint custody. What do they all mean? There are two main types of custody. One is physical. That's about how a child is being taken care of, where they're living, where they are when. The other one is legal. That's really about making big decisions for a child: where to go to school, whether or not they can go live with their grandparents for a summer. Big decisions. So care of their physical versus making legal decisions for the child. Two different kinds of custody. The other thing we talk about is sole and joint. Most people who are out of their relationship with their spouse or partner have joint custody of their children. Most commonly, they have both joint legal and joint physical custody. That's the most common scenario, that both parents have a legal decision-making for their child, they share it, and then they have significant parenting time with their child. That's the physical piece. But sometimes the court decides it's more appropriate for one parent to either solely make the legal decisions for their child, to solely be responsible for custody of the child, or to have both sole, legal, and physical custody. It's rare, but it does happen. In Connecticut, what the court looks at when they're trying to decide how parenting and custody should work is they have this concept called the best interest of the child. The court asks itself, based upon the evidence that the parties provide to it through their lawyers, what do I believe is in this child's best interest? Generally speaking, what courts believe is in the child's best interest is for the child to have a relationship with both of their parents. That's generally where we start. Now, there can be things going on in the lives of any particular family that make that not in a child's best interest. So sometimes the court says, nope, in this case, I think something that looks more like sole custody is actually in this child's best interest at this time. So generally speaking, most families in Connecticut have a joint custody situation with their children. The parents share custody. But in some cases, there's an award of sole custody. It's not common, but it does happen. Generally speaking, when there's an award of sole custody, there's something going on that makes it unhealthy for a child to be parented like that by that parent. You would think of situations like drug or alcohol substance abuse issues, health issues that prevent the parent from fully parenting, things like that. You'd see some pretty extreme situations before you'd get to the point of sole custody. Also, of course, if one parent isn't involved in a child's life, moves out of state, etc., and it wouldn't make sense for that person to have joint custody because they're just simply not functioning in that role, that's another scenario in which you would tend to see something more like a sole custody. Joint custody is far more common in Connecticut than sole custody, but we do see sole custody happen sometimes. And a lot of people wonder, well, when? When does it happen? The truth is that there are fairly extreme circumstances. It's usually when there's some reason that a parent either is unable to really be a healthy custodian for the children, or is unwilling to be a healthy custodian for the children. So here are some examples. A severe alcohol or drug dependency issue. Obviously, if there's not a safe environment for the child with one parent, it's more likely that the other parent will get sole custody. If a parent leaves the state and isn't engaged in caring for the child, they're essentially opting out of their parental rights and responsibilities, and that's another case in which we might see a court go with something more like sole custody. When you have custody orders in place and you're wanting to change them, you think changing them will be better for your child, the legal mechanism for doing that is to file a motion with the court to seek the court's assistance in revising parenting. Now, that doesn't mean that you and your ex disagree or agree. Some people agree to a parenting change. We write an agreement, all of the terms are negotiated, both parties sign it, and we present it to the court for the court's review to make sure from the court's viewpoint that that agreement is in the best interest of the child. So that does happen. A lot of times, though, there's a dispute on what's in the child's best interest. And so we file with the court to get the court's help to decide what's now in the child's best interest, given what's changed since the court's original orders. Some of the things that happen in people's lives that result in them going back to court to seek a modification of how parenting works are things like a child who gets very involved in an extracurricular activity as they grow up. So if the parents split when the child was 5 and now the child is 15, and has an active interest in a sport that requires travel out of state, etc., it might make sense to modify the court orders so that the parents can figure out how to either accommodate the child's interest in that sport or not, depending what is in the child's best interest. Other things that happen are a parent might have a job change that changes their schedule. And so the current schedule that the court ordered when the couple got divorced just doesn't work for the family anymore because of changing work schedules. So sometimes things happen in the parent's life that require adjustments to the parenting plan at some point in the future. You'll do your best when you're going through the court process the first time to predict situations in the future, but you won't be able to anticipate everything. And the reality is that the more you focus on figuring out how to communicate with your former partner in a way that allows you to reach agreements on your own and keep your focus on the kid, the better your chances are for a smooth process that can adapt as your child's needs change. It won't surprise you to know that sometimes after a divorce is finished and final, things change down the line. And one of the things that can change is where you want to live. Relocating when you have children is a big issue that happens post-judgment or after a divorce. It's one of the most hotly contested things that can happen in a family after a divorce. The reason for that is that when someone is trying to move in a way that materially affects the existing parenting plan, the court is going to take a really close look at that. So here's some of the things that you want to know and think about if this is something you're considering or you have a co-parent who's considering. When someone wants to move with a child, one of the first things that your lawyer is going to want to look at is what your original court order says. A lot of times there's language in there that explains how far parents can move before they have to go back to court. So for example, it's possible that you're going to move a few neighborhoods or to a neighboring town. If it doesn't impact the child's school system, that may be something that the existing court orders permit. But bigger moves that will affect more of how parenting works, things like how drop off and pick up work, how long a child would be in a car, again, what school system a child is in, things like that. Those are things that a court is going to want to take a look at and really decide if there's a legitimate purpose for the relocation and if the move is in the child's best interest. I think the important thing to know is that when the court is looking at potential relocations that fall outside what's permitted in the original court orders, they're really focused on the child. Is the relocation best for the child? Is the relocation in the child's best interest? And one of the things you're working against is that there are existing court orders, and when there are existing court orders, sometimes it can be an uphill battle to change those court orders. Another factor is if your move will materially impact, your proposed move. If your proposed move will materially impact the other parent's parenting time, that's something the court's going to take a real good look at to make sure the pros outweigh the cons before the court says, go ahead, you can move with the child. For couples with children, parenting and custody are some of the most important things that you'll decide during the course of your divorce. Sometimes parents get along, they make custody decisions together. That sets them up probably for a future of co-parenting well. But in other cases, there are really different parenting perspectives, really different parenting styles, and we have to be really strategic when we're working with our clients to make sure that we set the stage for a parenting plan that really works for the children.